Hi, my name is Miriam Cruz. I am a certified probate and trust specialist. I work with families that are going through probate or have a trust and need assistance with real estate. And today we will be talking to Carmen Rosas, who is the founder of Carmen Rosas Law, and she's an attorney here in San Mateo County. So thank you for joining me, Carmen. We met each other actually a few years back when we were working. Were you a part of the coaching program that I was a part of?
Yeah, with Chandra.
Right. Yeah. So we were actually a part of a coaching program. That's how I met her, and I knew that she was doing great things with women. She was an attorney, an author, a speaker, so many wonderful things. All the things. You also speak Spanish, which is wonderful, and you specialize in estate planning.
Yep.
So I wanted to make sure that I brought you on today because you have so much value to add, especially here in San Mateo County and in the Bay Area. Is there other counties that you work?
Yeah, so we serve all of California. We do all the way to like San Diego past Sacramento. So we're able to serve everyone in California.
Perfect. And like I said, she does speak Spanish, which is very helpful because many people that reach out to me are looking for an attorney who speaks Spanish.
Yeah. And I'm actually one of like very few. I can't even like figure out, maybe there's one or two others like in Southern California, but in terms of the Bay Area, like we have clients for that reason who reach out because they're looking for Spanish-speaking attorney.
Perfect. So as I mentioned, you're an author, a speaker, and you work here in the county as an attorney. Tell us a little bit about yourself and how you started your business.
Yeah, so that's a great question. And always, so when I'm first generation college student, only attorney in my family. And when I was getting ready to graduate and take the bar exam, actually when I was waiting for the bar exam, my grandmother passed away. And she had this DIY trust where she had pulled random documents off the internet and filled them out. Obviously they were filled out incorrectly because she didn't really understand what she was filling out. And at that time, my mom was her caregiver. My other aunts had moved away, and my grandmother left her house to my mom, and my mom was just devastated. She was like, I just lost my best friend. I don't even know what the legal process, like what do we need to do? And of course, because I was like waiting for bar results, they figure, oh, she knows everything about it, right? At least I could understand the language. And so at that time, I was working with an attorney who said, hey, if you do all the work, I'll mentor you through what we call a Hegstead petition. You probably have heard of it, where the assets aren't actually in the trust.
Okay.
And so we went through that. And as I was going through the process, for me, I was like, okay, it makes sense. But I was thinking about all the people who lose family members and don't have somebody who's waiting for bar results, right? Who has gone through law school. And so I was like, well, why don't I just get into estate planning? I knew that I was going to start my own practice right out of law school because I wanted the work-life balance. And so when I got my bar results, I started my law firm and we went into estate planning.
Wow, that's amazing. And it sounds so easy.
It sounds a lot easier that, people were like, are you crazy? And I was like, well, the great thing was, though, is I went to law school at night, so I worked full time, which means that I learned what I learned about myself is I didn't want to work for a big law firm because we would be doing 80 to 90 hours a week, right, of work. And if I ever wanted to have a family, I wouldn't be able to be at home with my daughter or like do the things that I wanted. I wanted the flexibility.
Yes.
And so I left the law firm after about a year and a half and then started working at solo firms. So individual, attorneys who had like waited a few years to start their practice.
Yeah.
And I learned the ins and outs of building a business, being a practicing lawyer, which you don't learn in law school. And so I felt comfortable enough to jump into like my own space because I had the experience under my belt.
That's amazing. And with that being said, you also work with women, right? You do a little bit of coaching.
Yeah. So I feel like the biggest thing, like my mission in life is I help disrupt the status quo, whether that's women following, traditional norms of just being told they have to play small. And part of that started when I found out I was pregnant. So I was 2 years into my business and I found out I was pregnant. I was like, oh my gosh, I'm not ready.
Yeah.
And every piece of advice that I would get was that, oh, your life is over. Oh, you have to be a martyr. Oh, your kid's going to be everything. And I was like, you know what, hold that thought, because I'm going to show her what's possible without limits. And so as I shared my story of like becoming a mom and my own personal development journey, there were so many women that were like, oh my gosh, same, how do I get out of it? And then moving forward, right, when the kids go off to high school and they've given up their lives and they're like, what do I do now? Like, I don't even know what I like to do. And so a lot of that is, how do we keep that as we grow and develop in our different stages of motherhood, while also living our best lives, because we deserve it.
Right.
So I do that. And then the other part at the same time, because I was going through this like spiritual and personal development journey, I was like, okay, I've been doing this 2 years. I'm prepping documents to help people protect themselves and get ready for death, essentially, right? I said, but how are they living every day? What are they doing every day? And how can they be better? How do they want to be remembered? And are they doing the things that they want people to talk about when they die, when they're the obituaries being, written, or the eulogies being read? Like, will people remember them the way that they wanted? Or will they be like, oh, they were a workaholic, they never spent time with their, And so a lot of the coaching kind of developed from my own personal experience.
That's amazing. Yeah. And I think many of us don't think about that. Like, how will I be remembered? Or am I doing what I want to do and living the life that I want to live? I know for me, that was a journey. And that's why I participated in the coaching. Because I was like, okay, I'm a mom, I work, but who am I really? And finding out who I truly am and what I enjoy. And working in the space in real estate now that I work with families that are going through probate or have a trust, I deal with death every day. And I think about that often, like, how do I want to be reminded or thought about? Like, what accomplishments did I have, or did I impact someone's life? So I always think about that. I think maybe for you as well, because you deal with that every day. Right, in your business.
Well, it's like we're literally preparing the document, right? And one of the documents in our estate plans is remembrance and memorial instruction. It's like, do you want a party? Do you want mariachis? Do you want doves? Like, what is it that you want? Do you want people to not wear black, right? So it's even them thinking that far ahead, because one of my girlfriends shared with me that one of the hardest things when her dad died was picking the right song. Like, what song is going to like make him so proud and like he would have loved it, right? Like if he had been attending the celebration of life. And so we provide that document as part of our estate plan. And it's not a legal document, but it's like, it makes it easier for the people that we leave behind, because really these trusts and these estate plans, they're not about us, right? It's about the people that we're leaving behind, what we want them to remember about us, and how we can make it easier for them.
Absolutely. I think about my sister, who was also telling me, I don't want so-and-so to go to my funeral. So I don't know if that's something that can add.
You can exclude, do not invite.
How do I tell the person at the funeral, if it, if it ever happened, you can't be here? But if it was documented, I could at least refer and say, it's written right here, you have to go.
We can't. It was like in the disclaimer, do not let so-and-so know that, I died, or that when the service is.
Exactly. And I think we laugh about it, but many times it's such a sensitive, touchy subject that people don't want to discuss. I know an attorney who said dying is like talking about sex. Everyone does it and no one wants to talk about it. And I know in my profession, it's even a touchy subject when we're talking about listing the property or whatever the case might be, or what the person who passed away wanted. So I'm so glad that we're having this conversation right now.
It's so taboo. I mean, people don't want to talk about it. Death, money, right? Sex, they just don't want to talk about it, but it's there and it's important.
And we were talking earlier about bringing it up to a family member. I know a friend who brought it up to her parents and said, let's work on your trust before anything happens. And the parent was so upset and was like, do you want me to die? Is that what's happening? So it's really important to have these conversations. And again, we can share more information in Spanish as well for our Spanish speakers. So I wanted to ask you a few questions today, just to get more information and so our audience understands what probate and trust is. How do you think we can help someone that doesn't know the difference, or how can you explain what probate and trust is? So basically the way that I break it down to clients who call and they're like, I heard about a will, I heard about a trust, or what is this probate thing, is that I say you have 3 options when it comes to estate planning, right? And how your house gets transferred. You do nothing and you end up in probate, right? Which you've experienced. That means you have absolutely no documents in place. It's a long court process. I think it's like at least minimum 18 months at this point with like COVID and just the extension, right, of
everything takes forever in the courts. And then if you need property sold, right, getting it approved and all those things. So depending on the probate, minimum is like 18 years with accounting.
18 months.
Yeah.
18
months, yeah. 18 months would be like
Yes,
forever.
yes.
I mean, people would definitely get their trust
Yes.
done then. But 18 months, right, if that's an easy probate.
Right.
And it's about 5% of the fair market value. So fair market value being what your property could be sold for. So even if you still have a mortgage, doesn't matter, right? The court doesn't care, the state doesn't care. They're looking at fair market value of the estate.
Right.
So it's about 5% and it's structured and set by law. That's second
the fee.
option, that's the fee.
That you pay for going through probate.
So
Yes.
the time is about 18 months,
Yes.
more or less, and the fee for probate is about 5%.
Yes.
Fair market value. The second option is you have a will. And sometimes people are like, I have a will, it's fine.
Right.
Not really, because the will still has to go through the probate process. So basically, option one is probate. It goes to next of kin, right? So your blood relatives down your bloodline, or if you're married, right? But they have it, and it's called intestate succession, where it gets distributed to whoever is left. Option two is the will. The will goes through probate, but the difference between having nothing and having a will is that the will is instructions. So say, for example, I have a partner who we're not married, so by law, they have no rights to my assets, right? But say we have an agreement that I want him to receive 50%. In the will, I'll say he gets 50% and then the rest goes to my daughter, 50%, where she would have gotten 100% if it was in probate. So the will gives instructions that allows you to be a little bit more specific than the intestate succession, but you're still going through the probate process, you're still paying the fees, you're still waiting on the court's timeline. And then the third option is the trust. And the trust allows you to have your trustee. So basically, I like to say a trust is like a treasure box. Everything you own goes into it, you hold the key. When you die, you get to pick who gets the key. And that person gets the key and can have access to it immediately for the most part, right? There's an administration that has to happen, but the length of time could be 4 months maybe, or you get it immediately if there's waivers signed. Those are just little details.
Yes.
But the trust is private, whereas anything that goes through court is public record.
Exactly.
Everybody and their tias down the street or, you know, the nosy neighbors can see, oh, what did they own? What assets do they have? What debt did they have? You know, how many credit cards? All of that is, your business is out there. So a trust is private. You can get immediate access, or your trustee or your family members, versus, right, with probate, assets are frozen at least for 60 days until you can get letters of administration or you can get the process moving. Everything gets frozen. But a trust, again, accessible immediately. Cost ranges from, I know there's like people out there that do it for like, $5.99, right? With like add-ons and things, a trust.
Yeah.
And they add it on. But average, when you're working with an attorney and you get with a professional,
yes.
and the other part, right, is, and I'm going to clarify, but there's like document preparers, there's notarios, and there's attorneys, right? So a lot of them will all say that they prepare, but attorneys are the only ones who can give legal advice for your specific situation. And so a trust with a professional, with an attorney, typically ranges from $3,000 on up, depending on your assets and the size of your estate, because we also have estate taxes, and so we have to be mindful of that. So if you have a larger estate, it can be a little bit more expensive because we have to do special tax planning. But to reiterate, the differences are probate, right? No documents in place. It's 18 months minimum. And 5% fair market value. Yes. And that's set by statute. The second option is you have a will. You're basically just giving instructions to the probate judge and you still go through that probate process. Same cost and time, 18 months, 5%. And then you have a trust where you don't have to go to court at all. Everything is based on what you decide and what you put in the documents. And the cost ranges from $3,000 to, we'll say $7,000 on average if someone has like a bank account, a home, and children.
Yeah. And those fees are pretty much here for California because it varies.
That's for California, and everything varies by state. Mm-hmm.
And I think clearly option 3 is the best one, having a trust. Many times I represent people in the real estate field when they don't have a trust. Mm-hmm. That's how I come in. Yeah. And I've seen a family, I mentioned to you, pay up to $150,000 for attorney fees because they didn't have a trust in place. So I know some of the people that I speak with say, no, trusts are so expensive, but you can pay so much more going through the probate process. Yep. And just to reaffirm, having a will not keep you from going through probate.
Nope.
It's just instructions.
Yep. A will, in order to be, I guess, like legalized. And a lot of times people will come to me and they're like, oh, we need to file my estate plan. And a lot of times it's my Spanish speakers who come from Mexico and they have just testamentos and you have to file it and register it, right? Well, in California, we don't do that. So a will doesn't get filed or lodged with the court until you pass away.
Yeah.
So at that point, you submit it to the court. And if the court says, oh, they didn't have a trust, because you can see, right? Typically what happens is if you have a trust, you also have a will, and I'll explain why we have both. And the will is what gets presented to the court. If you have a trust, the will says everything I own goes into my trust. So the court's like, all right, see you down the line if we have any issues.
Yes.
If you have a will and it says it gets distributed to these individual people, it says, oh, you have to go through probate. And so basically at the time of death is when the courts and the judge will become aware, oh, which way do we go based on the will? And that will gets filed.
Yeah. So many times I see the files for my clients and I could see sometimes they're excluding someone. If you don't like someone, you can exclude and say this person gets nothing.
Yeah.
Or my kids will get $1 because they didn't treat me well. I've seen that too.
Yeah.
So many things that happen. So I think it's really important to put that in writing, right? And have it validated. And you don't have to share with people around you, right? When you're creating that, it can be private conversation between your attorney and yourself.
Yeah, absolutely. We get so many different family situations, right? Everyone's family is like different. I promise, yours is not the worst. So they're like, oh, you probably never heard this. And I was like, bet me,
Yes.
I probably have. So people ask, oh, do I give this to the people that I named? And I'm like, no, like you just keep it for yourself. If they're like, if you want them to know that it exists, say here, contact my attorney if something happens to me, or I'm going to keep these documents in this folder, on this bookshelf, wherever it is, in case you need to access it for emergency. But I always suggest that clients keep it private, because what if you get into a fight with the person you named as a trustee or guardian that's going to take care of your kids, and we're not friends anymore, and you want to update it, or you remove somebody and you're like, they were getting 50%, now they're getting nothing, or they're getting $1 because, for example, with my grandmother, she, my mom and her sisters all thought they were getting equal share. There's 4 of them.
Yeah.
And all 3 of them moved away, and my grandmother was hurt that her kids never came to visit, right? They never came to help take care of her. So she left everything to my mom, who was basically her caregiver for 5 years.
Yeah.
And so at that moment when we were going through all the documents and my aunts realized we were left out, they were hurt. But so much of their guilt comes up, and that's where it leads to fighting. But had it not been in writing, it would have been a mess. It would have been. We would have ended up in probate. Everything. People would have been fighting, right? And so.
Yeah. I've seen situations like that where the family member didn't leave a trust and just told the kids prior to passing, share everything. And then it's a huge fight. One of the siblings believes they deserve it all because they took care of dad for 3 years and no one showed up. And in fact, one of the cases that I helped, someone died during the probate process and it got even messier. So I always encourage people that I work with to get a trust.
Yeah.
Because that can save so much pain, drama, money.
Yeah.
There's so many things.
Yeah. And then, the thing is with probate, and especially if there's fighting and there's no agreements, is you end up spending all of that money that could have been split amongst everyone. It gets spent on court fees or attorney's fees.
Yeah. I even had a situation in which the person didn't file to probate, lost the house because she didn't want a family member to get any of the money related to it. So there's so many things.
Yeah.
So I think it's really important to be prepared and create something, a trust to, for everyone to know, if anything happens to you, what shall happen with your funds.
Yeah.
Does anyone qualify for a trust? Can anyone create a trust?
Yeah. So people ask me that all the time. Anyone can, the threshold for probate is, I think, $188,000 now, something like that. And so if your assets are more than $188,000, you definitely want a trust. If you have less than that, you could get away with a will because that amount doesn't have to be probated. So you could do the will, but if you have minor children, you want to have a trust, even if you don't have a lot of assets, because even though you're, say, at $150,000, say the only investment you have is $150,000 in a brokerage account, you want to name the trust, because what happens is that the person named becomes the owner of it. So if you name I'm going to name my mom to be to manage the money for my daughter, my mom can take that, not that she would, but my mom could take that money and run off with it and be like, I don't know your kid anything. My name's on here as the beneficiary. Right. I'm the owner of it. And so if you have minors, regardless of the amount, I say create a trust. If you are, and if your assets are over 188,000, and if you have real estate, create a trust.
Right.
So those are kind of like the three things. However, if you have no assets yet, right, or you're like just starting out and you're building up your net worth and your wealth, I say create a trust, because as you build it, you just add it to the trust and the container already exists. It may be empty, but you can always add as you build.
Just keep on updating. Yeah.
And you just need to update as long as you're taking those assets in title, naming the trust as the beneficiary. It'll just become part of your trust.
So now let's talk about some common issues and challenges that happen when creating a trust.
Yeah, so I find the biggest issue is who's going to be in charge. Who am I going to leave in charge when I become either incapacitated or pass away? And obviously a trust is called a trust because, well, it's not actually this reason, but it's somebody that you trust.
That makes sense, actually.
I was like, it's somebody that you trust.
That actually makes sense.
Because somebody is going to follow the rules that, or the instructions that you put there. They're not going to like abscond with your money and run off with it. Like, it's somebody that you trust. And actually, I will share, because we're talking about trust, a probate that I had early on working for the firm, for that attorney that kind of mentored me through. We had a situation where the beneficiaries were in China and London. It was one little house. And back then, I was like, 2011, I want to say. It was a house in Stockton valued at $300,000, right? Which is not significant. It's like tiny estate. But the person that was named as the administrator, because it was through probate, ran off with all the money.
Wow.
And there was no bond in place because they were like, no, it's fine. We can sign waivers. We trust this person. And the person ran off with all the money. And so I say that only to say, right, with probate, there's some protections in terms of like bonds and things like that. But with trust, you get to pick the person. Whereas in probate, anybody can say, hey, I want to do it. And if the judge sees no issues with it, then.
Yeah, I've actually encountered cases in which the neighbor tries to file for probate when their neighbor passed away, and then the child shows up and says, hey, that was my parent. Or squatters move in, or different things happen. In fact, I read about a case recently in which someone came in and removed all the personal items from the decedent, the person who passed away. In fact, I've actually seen that in one of the properties I sold in San Francisco. I came over to clean the house and prepare it, and her purse was gone. The lady who passed away, everything was gone. So people hear about death, some people, and jump and take whatever they can. So that doesn't surprise me, because it does happen. I'm glad that you brought up the bond because situation. I do have a lot of people that reach out to me for a bonds company, and I know of some because I work in this industry. Tell us a little bit about a bond, because I think that's an additional cost in probate that people are not aware of and are really not happy about when they find out.
Yeah. So depending on like the bond size, right? Like the estate size, you need a bond, which is basically like an insurance protection mechanism. So somebody doesn't run off with all the money. And if they do, it's insured, right? That those assets are insured. Meanwhile, the assets get distributed or whatever. And so a bond can be, I think the smallest bond we had was like $1,100, but that's $1,100 that you have to fork over in order to insure it and actually to move forward. If the judge is not willing to waive bond, beneficiaries are not willing to waive it, you need to pay. Minimum is like $1,100. And then that renews annually depending on how long the probate goes. So if you have a probate for like 5 years, you're paying $1,100 every year, and that gets deducted. And that's not included in the 5%.
Right.
Yeah.
So I know someone reached out to me in the past, and she had bad credit. So she couldn't get a bond. Have you seen that issue before?
We have not, but I've had issues where clients have to get like hard money loans, right? Because they can't pay any of the money, or they can't pay any of the fees, like even to get started.
Yeah.
And so they have to get like hard money loans. One, because they don't have like income and they have bad credit. And so we haven't dealt with it where they couldn't get a bond.
Yeah.
Either it's like, two siblings will do it together and that's how they get the bond, or.
Yes.
Yeah.
I could see that. So that I think there's definitely issues, like you mentioned, with the trust and also with probate that can come out, especially when you have creditor claims.
Yeah.
Right? And tell us a little bit about creditor claims. That's a whole nother one that people are usually very surprised.
Claims, yeah. I mean, the nice thing is, right, like if you have a trust, a lot of times if you call the credit card company and, it's not for a car and it's not a mortgage, right? If it's like unsecured, or if it's like, if it's unsecured or like a medical bill and you're like, oh, the person died. And they say, oh, do they have a probatable estate? No, they don't. I mean, it's not going through probate, right? So you don't have to submit this claim. And basically what a creditor's claim is you submit to the court, you send out a letter to all the potential creditors. So all those bills that keep coming in, medical bills, credit card bills, you send a letter to the credit card company and say, hey, if you want to collect your fee, submit it to the court. And they have a certain amount of time to submit it to the court. If they submit it and there's no reason why it can't be paid, it gets paid. If they don't submit it, then they don't have to worry about it, right? The beneficiaries don't have to pay it. When you have a trust, you don't have that same requirement. Like you have to call them and say, hey, this person passed. There's not a probate that's going to be opened. What do you want us to do? And a lot of times they just kind of clear the debt, right?
Yeah.
Like disclaimer that this is not legal advice, any of that.
We're just having a conversation,
yes. And it's not guaranteed, right? That they're just gonna. So sometimes we're like, okay, well, it needs to be paid, and if they go deeper, which they normally don't because the customer service reps aren't set up that way, or they'll send it to their legal team, but 80% to 90% of the time, it gets just kind of washed, right? Because this is just off topic, but debts typically pass when you pass, as long as it's not community property and it's not secured. So for example, if it's a car payment and you have a car note and you stop paying the car note, they'll come and repossess the car. So if that's the situation, then
that's different.
Yeah, it's different. Same with the mortgage.
Yes, I think it's such a great topic as well because there was a situation in which one of my clients, her husband passed away. So we were selling her condo in San Francisco. They had a reverse mortgage and he had so much debt. So they did file the creditor claim. At the end of probate, she had no money because everyone else was able to collect and she wasn't. So many times I find that that's also another issue that people are not aware of. Yeah. So again, having a trust is so much better. Yeah. Yeah.
And the other part too, right, is like I think about like long-term, like for older people, right, who have like long-term care or like bigger medical bills, they can potentially lose like, or the spouse can lose anything that they would have taken on the family home because there's medical bills that need to be paid. Or if like Medicaid or Medi-Cal, if it's not in a trust, they can come back and say, hey, you owe us money for these services that we basically provided for your spouse. Yeah. And then you have to repay those things back. And so if it's going through probate, Medi-Cal, Medicaid can do essentially a creditor's claim and get all their money back and leaves the family with nothing. But if it's in a trust, they don't recover.
Right. And if it's going through probate, anyone could actually create a creditor's claim, right? A cousin that says they were owed money.
Yeah. And so obviously, like in that situation, and I say that all the time, right? Like my cousin could come and be like, well, Carmen said she would pay me back $500,000 and create this thing saying, forge my signature, right? Like do all the things and then submit it to the court. And if there's no proof that I never did that we have to get signature experts in, like it can just be more just headache messy. And money. Yeah. Then the judge will be like, well, pay it, right? Yeah. If it's a good forgery. The other thing is, right, people who just want to be jerks, right? And like, say I have a cousin that like I'm beefing with and they don't want to, they can submit a claim just because they feel like it and extend the probate process to be even longer or, for whatever reason. And it just, because it's a public forum, anybody can submit whatever they want, and regardless of the legitimacy, it would then be the judge, which means it's an extra court hearing, which means it's more time for the attorney and more money.
I know. It's a lot.
So,
yes.
Yeah.
So now, why do you think, we've heard so much about the reasons why someone should get a trust. Why is estate planning so necessary?
Yeah, so I think estate planning, trust, wills, like those words get thrown around a lot. And so estate planning, just to clarify for everyone watching, it's this umbrella, right? Where it includes numerous documents. It includes a trust, it includes a will, includes an advanced healthcare directive and a power of attorney. Now, the trust and the will work together upon death when you pass away. Incapacitation, when either you have dementia, say you're in a car accident and you end up with brain damage and you can't make financial or medical decisions for yourself, the healthcare directive and power of attorney then step in. And so when we create an estate plan, we're creating a comprehensive plan. So if you become incapacitated or if you pass away, your family has these documents in place to make sure they don't end up in court. And when emotions are high, right, there's already kind of like a plan and, logical next steps in place without people trying to figure it out while emotions are high and they're still trying to navigate things. Right. Or especially if it's a car accident, right? Or there's some kind of an emergency, they're like, oh my gosh, or somebody passed away. Like, people can't think straight. And so in that moment, things can happen that would not have been in the best interest of the beneficiaries or the people left behind. So having an estate plan and all those documents at every stage of life is super important.
Yes. And an advanced healthcare directive can specifically say if you're incapacitated, what shall happen.
Yep.
I know something that my sister and I were talking about is if I was in a coma. And she's like, no, I would just leave you there. And I'm like, I don't know if you can or not, but no, pull the plug. Yeah. I don't want to just be there. Well, I mean, after a month, you could pull it.
Yeah, so I get a lot of, when it comes to the healthcare directive, and they're like, but some people, there's like a miracle and like 10 years later. And I'm like, look, do you know how expensive that's going to be? One. And two, if the doctor's saying there's no brain activity, right, do you really want those costs and expenses to kind of build up, right?
Exactly.
Because, but yeah, so you can have a healthcare directive that says, if you want to be an organ donor, if you want to donate your tissues, if you're going to stay on life support, or if you're like, just keep me comfortable. And then there's something that, just for clarification, is an advanced healthcare directive is different from a DNR. Sometimes people ask, I need a DNR, and I'm like, we don't do those. DNR is something that goes to the doctors and signs off, meaning like, do not resuscitate. And so when we're creating these plans and we're thinking about medical decisions, when we look at the healthcare directive, it's, if I was in a coma and I need a surgery, who's making those decisions for me?
Yes.
Do they understand what I want done to my body? It's basically maintaining autonomy of your body and picking someone who's going to then make the decisions based on, your values.
Yes.
You can also put whether or not, if you're in a persistent vegetative state, right? Because there's two things that can happen. One, you're in a coma, but there's brain activity. So the doctor's like, oh, they can hear, but they can't respond, right? So there's still brain activity. The other is a persistent vegetative state, which means the doctor's like, there's no brain activity. They're just going to be there. They're just a vegetable. Like, you can't communicate with them. They have no idea what you're saying. At that point, right, you're like, pull the plug, please.
Yes.
Or you're just going to keep accruing medical expenses. And then with a DNR, it's a do not resuscitate. And so that's different in that if you select DNR, like do not resuscitate, that means even if you're having a heart attack, they're not going to pull the paddles out for you. So like someone like us, if we end up with a heart attack, please try to save me. Like, pull everything, like all the things, do all the
and
things.
Don't stop.
And don't stop. Right? And so, but if it's someone who's like 90 years old, they've had cancer and they're just kind of waiting, right? And they're like, please do not try to resuscitate me. If I have a heart attack and I die, let me go.
Yes.
And so the DNR can only be done by a medical professional. And that's because there's a big differentiation between being 90, right? And I don't want any support to kind of bring me back. Being our age, and you're like, yes, try everything necessary. And so there's essentially two different things, right? So it's the Advanced Healthcare Directive and the DNR. But
thank you for explaining that. I don't think I've ever even heard of that.
Yeah.
Or I've never seen it in a trust.
Yeah. No, and so that's why I was, a lot of times people are like, oh, I need a trust, I need an estate plan. An estate plan is 4 different documents minimum, right? And a trust is just one part of an estate plan.
Thank you for sharing that.
Yeah.
And the person who is handling the trust, if the owner of it dies, is a trustee, right? Do they get paid for their services?
They can.
Okay.
And it's like reasonable compensation is the legal language that's put in. But typically, if it's a fiduciary, right, like somebody who does this as a professional job, it's like $60 to $80 an hour. If it's someone like, say, you or me who aren't, well, I'm not a fiduciary, but could do. So if it's someone, off the street and this is not their job, maybe they're a car mechanic and they're trying to figure this out, they would get like $30 to $40 an hour. But the key is they have to keep track of all their time. And a lot of things that people are like, well, what if they just try to take, more money than they're owed? Well, then you have the beneficiaries who will look at that accounting and be like, this doesn't look right. You're not entitled to that much money, and they can object to it.
Yeah, I've seen that
so
in court as well. Yeah, so the judge has a little bit of information.
Yeah.
I've seen someone bring another person to court saying, "Hey, you're not doing what you should be doing."
Yeah.
And how hard is it to remove a trustee? Do you know?
You have to file a petition. It also depends on the language of the trust, right?
Yeah.
Because sometimes it says if a majority of the beneficiaries want to remove the trustee, then they can. Right? Or it has to be like unanimous decision. And so there's sometimes language in the trust, but otherwise you file a petition with the court. And if you can show, because you have the burden of proof, whoever's petitioning, that they're not doing their job, you can have them removed. And to be honest, the tricky part about probate is it depends on the mood the judge is in, right? Like if they've dealt with like nightmare cases and they're like, not these guys again.
Yes.
They're going to be in a bad mood, and they may not rule in your favor. Had you come back the next day and he had easy cases or she had easy cases, she'll be like, okay, fine, based on evidence. It's a lot of that impacts. And so if you want to go not do a trust and you just go through probate, that's another thing that, yes, there are laws and like, well, they have to follow it. Yes, but also there's a lot of gray areas within the law. There's loopholes. And so
I don't know if you were aware of it, but I was the supervisor at the courthouse.
Well.
And I was also a clerk. So I work with multiple judges at the courthouse here in Santa Clara County. So I have seen when judges are in a bad mood, I would sometimes warn the attorneys, today's not a good day to be messing around, because it can impact the caseload and the filings and things like that. So I don't know if that's like common knowledge, but
no, I don't think it is. Well, I mean,
don't say that out
you're
loud.
in the court. Yeah, I know as an attorney, all attorneys know, right? But like individuals who are just coming in, and I think that's why sometimes judges will get frustrated, right, with people who are not represented, because they have to do so much more explaining because the individuals are not trained in the area of law, and then they're just. And a lot of times when people are in a court, especially when it's a high emotion thing like probate, they just want to be heard. Like there's so much like that they actually need to go to therapy for, but they want to like do it in court because they feel like, well, if the judge just hears my story, they're going to understand. And unfortunately, that's not the case, but that's a whole other, that's a whole other conversation.
And I've seen that many times. It's actually a great topic as well to pro-pers, or people that are representing themselves and choose not to hire an attorney because they feel that they can do it themselves. And I found cases that are going on for 4 years.
I was like, it gets a lot longer. Probate, like that 18 months is if you have an attorney that knows what they're doing. If you have a pro-per, it can be 5-6 year, it can be insanely long. Or if they want to do everything themselves, like rather than, we had a probate where the representative, the personal representative, did not want to hire an accounting person to do all the accountings for us. And we had to go to court 4 or 5 times because the person that was doing, the representative was doing their own accounting, because they're like, oh, I can do it, I can figure it out. And the numbers weren't matching up.
Yes.
And it was off by like a couple of cents, or it was more than a couple of cents. And the judge was like, nope. The probate examiner was like, nope, it's not matching up. The numbers have to be exact. Until finally they let us hire our accounting person to do all the numbers, and we were done.
Because when you make mistakes, and that's what I tell people when they're representing themselves and I see them going through the court process and will reach out to me, any mistake, you have to fix that mistake and go back to court.
And it's at least 30 to, really the reality is it's 60 days for you to get a new court hearing.
Exactly.
Like, it's not like you can just go back next week or the next day. You're waiting 60 days now if you mess it up or you missed one form. And because also, right, at the clerk's office, they'd be like, well, here's the documents, but if there's like nuances specific to your case or things like that, they can't advise you. They're not allowed to give legal advice. Even when you go to like self-help and they're like, oh, let me fill out this form, they can say, okay, fill this out, and they just make sure you filled it out right, and that's it. They're not giving you any legal advice.
I go to the courthouse once a week, and I see people that will ask the clerks, can you tell me what to write here? And the clerk will always say, I'm not an attorney, I'm not allowed to give you advice. No, not advice. Just tell me.
Sorry.
We're not going to tell you how to fill out the forms. So I do know that it can be very confusing. And if they're not accurate, you're going to go back to court.
Well, and the other part is, right, for those who are watching that may have like family members that are Spanish speaking, the documents are all in English.
Yeah.
Right? I have clients that ask me all the time, can you write my trust in Spanish? Well, I can, but it's not going to be valid. And so we have to, all the legal documents need to be in English because that's the language of our state. And so if they're not understanding the terminology or what to write, it's going to be a lot harder for them.
Absolutely. Great conversation. So tell me about any legal benefits or, tax benefits, any tax benefits for probate or trust?
No tax. I was like, I don't see any tax benefits of probate,
yes,
right?
Okay.
I was like,
So
I was like, is this a trick question? No. A trust is the way to go for a couple of reasons, right? And so you can avoid capital gains is like one of the biggest ones, which in this area, right, the families that come in, and if they've owned their houses for even 10 years at this point, because the amount of equity that has, the houses have, the values have gone up significantly. But if you came, and I think about a lot of my clients who come, they buy their one little casita, right, their one house that is $60,000, $100,000, which is like unheard of now, unless you're, moving out of state. So they buy it for that much, and now it's worth $1 million, $1.2 million, 1.8, right? When you look at the value, so say somebody bought their house for $100,000 in East Palo Alto, East Menlo Park, right? It's now worth 1.8 million, which means that the equity, right, is 1.7 million. And if it doesn't pass through a trust, you don't get what's called a step up in basis, which means that when you die and you go through probate and your family decides to sell the home, they're paying capital gains on that 1.7 million. If you have a trust, you get what's called a step up in basis, which means that it's the date of death value. So even though the parents may have bought it for 100,000, when they die, it's 1.8 million. They get that step up to 1.8 million. And so if they sell it within the year, typically they can avoid capital gains. If they sell it, say 10 years down the line, and now it's 2 million, the capital gains that they're paying is going to be not the 1.9, right? So even if they waited, it would only be the 0.2 or 200,000, right? So from date of death to date of sale, and whatever the equity is, capital gains on that.
Got it.
So it can save you a ton of money, because that capital gains, I think, is something like 10%. Like it's percent, percent-wise doesn't feel like a lot, but when you're looking at like $1 million,
absolutely,
it adds up.
Yes. I've heard of people asking the parent to change the title before they pass away. Do you think that's a good idea?
I don't. Okay. I get that a lot.
Yes.
They're like, I'm just going to add my son to the title. Oh, just wait and let them pass. The other thing, though, that exists is Prop 19, which is newer. And so a lot of times, especially people, like if you have one house, don't add your kid to title. Create a trust, let it pass that way. If you have multiple properties, sometimes there is an advantage, mostly because of Prop 19, right? So we used to have Prop 13, which basically the kids could just take on any property taxes that the parents already had, the value, right? Now, Prop 19 says they have to live in the home as their primary home, and anything upwards of there's like a calculation, right? Upwards of $1 million plus like purchase price, they have to pay or gets reassessed at a new property tax value, right? And you're probably more familiar with property taxes and all of that. Yeah. And so adding the kid to the title, you lose potentially that bigger step up in basis on capital gains, especially if you know that they're gonna sell. It's a gray area when it comes to, that kid's gonna live there forever. Maybe, or they're not gonna sell it, or it's gonna pass on to like the next generation. And so really looking at the purpose or what the beneficiary is going to do with the home.
Right.
But if you're adding one kid, like I had a situation where they added one son before consulting with me, and they're like, well, now we want to make sure that it goes in equal parts to all our kids, but including his half. And I was like, but that's his half. So unless he gifts it back to you, right, which is just these back and forth transfers that can get sticky and looking at, all of the numbers, you can't force him to give any of his share to somebody else.
Yes.
And so we ended up doing it where the son gave the 50%. Actually, the son, because he was claiming it on his taxes, he gave back 25%. So basically he received his 25% while living, and then his other 3 siblings are going to get their 25% upon death. But capital gain, right? If they end up selling it, it gets messier.
Yeah. So there's definitely a lot of tax information to discuss with your attorney, you would say, or
yeah.
okay.
And some attorneys aren't comfortable, but I'm like, look, this is the reality of like, I mean, obviously I'm a huge proponent of a trust because there's lots of benefits, and sometimes I do want to clarify is people are like, oh, but it's going to cost too much to maintain. And the thing is, people are like, you know, Instagram, TikTok, social media, we have people who are learning about different kinds of trusts and they're sharing information, but they don't really fully understand how it works. And they're like, depending on the state, right? California does not like asset protection trusts because they can't collect money, right? And so a couple of things, right? Where my head is going is, one is if you create a trust, so say I create a trust and my daughter decides to leave the property that we have in the trust, that trust that I've created now creates an asset protection trust. It's irrevocable, which means that she goes through a divorce, if she gets sued, if she files for bankruptcy, my house will always be protected, and then essentially pass on to my grandkids.
Okay.
And so that's when people are like, oh, you need an irrevocable trust. But California doesn't like when you set it up in that way. Now, if you set it up because you're like, oh, we're going to reduce estate taxes because my estate, right now the estate tax exemption is $12 million per person, $24 million per couple. In 2026, it's going to sunset to about $7 to $14 million. If your estate is larger than that, you have to do special tax planning, right? To make sure that that money is either like distributed during your lifetime, which is like you could do $18,000 per person per year, so you can do lifetime gifts. But anything that's left when you pass over the estate tax exemption will get taxed for estate taxes.
Wow.
And so working with an attorney, if your estate is that large, you want to make sure that, you know, you talk to an attorney to figure out the tax planning. And then the other thing, I lost my train of thought. I was like, there's so many things that are like, oh, all of this information. So that's the one. Going back to people are like, oh, it costs too much to maintain. Well, if we're doing a situation which many of my clients do is they create the trust, the house is going to be split into 4 ways. Either they're going to sell the house or they're going to take that money and buy their own property, right? So at that point, at the second generation, it ends. There's no maintenance fees. Now, when you look at an estate that is irrevocable, has a large estate value upwards of 12 million, 14 million, right, in the future, and you do have to create an EIN once the person passes, right? So there are estate accounts and you have to file taxes. So if that trust is making a lot of money, you will have to pay taxes on it, right? If it's income, but it's taxed differently than like regular income tax, right? It then functions as its own separate entity. It's almost like you're running a business. So to maintain it, it costs money.
Yeah.
But one, not as much as probate, and two, you have to have a large estate for you to really feel the impact.
Yes.
And so that's one of the things that I get is like, well, it costs too much. What's cost to maintain it? You have to file a tax return like you would with any other business. If you don't want to run a business, fine, makes sense. But if you're in the business of building generational wealth, you're going to have to like invest a little bit and pay a little bit to continue to maintain that. It's
worth it at that point. Mm-hmm. Yeah, absolutely.
Yeah.
So talking about all this, I'm thinking now, how can you select? This is something that came up as you were talking. Many times people that have multiple children don't want to select one to be the trustee because they feel, well, so-and-so is going to get mad. So in one situation, someone picked 4 of their kids and now they're all trustees and they don't like each other. So they can't agree to anything. How can someone select, or what do you think their mindset would be when selecting their trustee for their trust? Yeah,
so a lot of times, like I'll tell people, you're dead. You don't have to deal with all that, right?
Yes.
And the thing is that people don't realize, they're like, oh, my kids will get along great. And I'm like, they're getting along great right now, because if not, you're gonna get the chancla and get after them, right? They're having childhood trauma. So they're getting along while you're alive. The moment you pass or you become incapacitated, and I will share that my dad is one of 8, and they're currently going through that, where there's all of this animosity. My grandmother's still alive, but she has dementia. That there is so much fighting. The family's already split. It's like, oh, whose side are you picking? And it's like, it's not about that. Like, please make sure that she's taken care of with the house that she came from Mexico and like built with my grandfather,
right,
who was passed.
Yes.
people, like, true feelings come out when it comes to the kids. And so if you're like, oh, my kids get along great, no, they don't. I was like, I'm telling you now, they won't when you pass, right? And so don't feel bad about who you pick, because sometimes you're like, oh, well, I'll just pick this person because it's the oldest. But it's like the oldest has been through like 4 divorces, filed for bankruptcy, and can't handle their finances to save their life. Do you really want that person in charge of like the estate that you've built and you want distributed, right?
Right.
And so it's looking at your 4 children, if you really want to pick one of them, right? I'm just using 4, but looking at your children or the people that you want to name and say how practical are they, right? Like what is their decision making like? And if you haven't picked anyone yet, like start just keeping an eye on people's behaviors, right? How do they act under stress when they're overwhelmed? Who do they turn to for advice? And so kind of watching that, monitoring that, and then don't pick more than one. Or if you pick one, right, say you have 3 and do majority rules, because you can't do 4, you can't do 2, because if there's a split. And so sometimes we'll put in language that says, when people are adamant about having 2 of their children, I'm like, but if they can't agree on like an investment decision, who's going to have the final say? And then they'll say, oh, well, you know, child number 2, not child number 1. I said, well, then you actually want to name child number 2, because that's really who you want to make the decisions.
Yeah.
The other thing is if they're like, oh, well, they'll, you know, they can figure it out. And I'm like, you need a 3rd person. So at least it could be who's going to be the tiebreaker. And the amount of times that I put that language in is a lot. But if they really don't get along and you're like, I really just want this person, but you feel bad and that's why you're including them, put them on the healthcare directive or put them as 2nd and 3rd. And I'm sure that they'll understand why certain people are selected, right? Even if they don't say it and they're like, oh, I know, like, you know, I've just been partying, like, you know, blowing my money as it is. That's why they didn't name me to be in charge of like all the finances.
Hopefully they understand. But I do have that case that I mentioned with 4 siblings and they don't agree. I mean, they're split 2 and 2. Yeah. So now they're hiring their own attorneys because they are in disagreement as to what the trust says. And I'm like, why would someone name the 4? And I had never seen that before. But it is important to
like,
think
I've
about
seen
that.
Yeah, so clients will come and they're like, oh, we didn't update it for 20 years. I think my attorney retired or died, right? And I'm like, okay, let's take a look. And I'm like, we're not going to keep all 4 of your kids. Tell me about your children. Tell me about like what their jobs are. Do you like their wives or significant others? Because that also plays a huge part in what their steps will be when you pass away. And so 3 is the most. A lot of times I will say, well, if it's 2 or they want like more than 1 because they like wanted checks and balances, I'm like, do not trust them. Like, what's the reason behind this? Because the truth is they have to follow what's in the documents. It's not like they're changing it or anything like that, but they still, a lot of times clients still get nervous about just picking one person and they're like, oh, I'm giving them all this power, which yes, but you know, you want to pick someone that you trust. The other thing is don't pick your kids. Find a fiduciary, find, you know, someone that you know, like I could pick you and be like, Miriam, you deal with probate, make sure that, you know, my kids, I only have 1 daughter, but make sure my kids, you know, get what they're supposed to. Yeah. And you can get compensated for it, right? So you're not, you know, and then they do the checks and balances. And sometimes that's easier because you avoid picking one, oh, I always knew that they were your favorite, you know, and all those emotions, like you avoid a lot of that.
Yeah. I see that also in real estate when people select me and they have a sibling who's a real estate agent. But there's so much conflict and emotional ties that it's like, no, let's hire Miriam. She's a 3rd party. She's not going to get involved. And it turns out better that way. Yeah. Instead of hiring a friend who knew the decedent and wants some of the property as well, it could get messy. Right. So it's important to work with people that you know will get the job done.
Yeah. Well, I have a client right now. They have a trust. They're doing the trust administration. And there's 3 of them. But 2 of them don't really get along. The 3rd one just kind of flops back and forth. So there's never like a really clear answer. And so they picked a real estate agent who they've known for like years. But the other ones are like, you know, I'm not really comfortable with that. Or why couldn't we have picked someone else that nobody, you know, that comes as a recommendation. It does happen. And then the thing is, when you have 4, you have too many trustees. It's just too many chefs in the kitchen, right? Everybody's trying to direct it. They're like, no, I get to decide. And it's like, actually, you have to come to an agreement. You actually just have to do what's in the document. It's not.
I also get stories whenever I'm hired to do a job and they don't get along. The siblings calling each other names. To me, one says something, and I'm like, I won't say this to the other person, but they really don't like each other, and let's just get the job done to make sure that the probate actually moves forward, because many times the probate's being held up if they're going to probate. Because the house is not selling. So I want to
especially if it's like the only asset. And you're like, we just need to move this along.
We need to get it going.
The other part too, right, is that somebody may be more emotionally attached, especially when it comes to property. It's like, oh, this is where we grew up. We have all these memories. And the other person's like, sell it. I want my money. you know? And so navigating that space.
I actually had a situation in which a brother, who unfortunately passed away after, but he lived in the property, and he didn't want the new owners to remove any of the bricks from outside because their parent had put him there. And I'm like, we can't control that. The new owner has the ability to do what they want with the property. So he's like, make sure you tell them they can't touch any. So I do get the emotional side. So talking about that, do you have any cases that you feel have impacted you, whether it's in a positive way as to why people should have a trust, or in a negative way that you can share with people?
I think my favorite, like some of my favorite cases are when I have these like immigrant families that come in and they're like, oh, my house, like we worked so hard and we saved, or even like the single moms that come in. Like I'm thinking of one right now where single mom, she's like, I never dated after like, you know, my husband passed because like we bought this house and I worked so hard for it and I didn't want to lose it. I want to pass it on to my daughter. But it's the pride that people have in like these homes that they purchased because it was like a struggle for them, right? And I didn't share that when my grandmother purchased her home, she actually purchased it in the 60s, shortly after women were able to get loans without men. And her and my great grandmother purchased that house together. And so it's always like, we have to keep, you know, like there's so many reasons like we have to keep this. But it's like stories like that where like, they didn't just kind of come into like wealth. Like, do I want that for my daughter? Where she's like, oh, I inherited like 5 properties. Yes, please. But the ones that I'm most excited about protecting, right, are the ones who are like, this is my house and I'm so proud of it. And like making sure that that little house doesn't end up in probate. I mean, I can't do anything about the kids fighting, but if we structure it enough where, you know, the parents feel excited and they feel this peace of mind that they're passing on this thing that they built to their kids, what their kids decide to do after that, right? Like I have no control over and I can't guarantee. But I get to structure a plan where my clients are like, this makes me feel good that if I die tomorrow, I know that my kids have something, they're not gonna end up in court, and they have this peace of mind. So those are kind of some of my favorite cases and clients to work with. I mean, I just am like, please create a trust so that we don't end up in probate, because the probate situation that I experienced, which was my first probate, when the administrator ran off with all the money, so we didn't get paid. The beneficiaries didn't get their money, right? Is like just one example of what can potentially happen, and it really just is a nightmare. As attorneys, right, if we can make 5% off of $1 million, we're looking at, you know, $50,000 for a probate. Not that it's easy, but it's easier money than getting in smaller estate plans, trusts each month, but they're a headache. Like even for attorneys that can potentially make tons of money, they're still a headache for us as well. And so just do a trust. Just create a trust. Like
I think it's part of building wealth for generations and building a legacy, which I know you're firm on that. And, creating that for your child or children. So I think that's very valuable. Is there anything else that you want to share that you feel, I know there's probably so much that we can cover at a later time that you want to share for our audience?
I will say that sometimes when people, and when I ask, right, well, what took you so long? Or they're like, it's been on my to-do list, right, to come create this trust. And if you find an attorney that you're comfortable with, that you can just have conversation with and that you trust, ask them questions, right, about how do I get started, right? If you're following Miriam, like you've probably seen not only me, but other attorneys that do estate planning that have been in this space. And I'm sure she has a ton of references or referrals for you, but find someone that you're comfortable with. And I know for our firm, we try to make it as simple and painless as possible, where we ask the questions and it's just a conversation like this. Well, what do you want how do you want your estate distributed? What are some of your concerns? How can we like support your wishes? And then basically extracting the right information to put it down on paper. And it can, estate plans can be done, trust can be done within like 30 days, right? It's not as scary as people think it is.
Yeah.
Probate is a whole lot scarier
Absolutely.
and time consuming.
Yes.
So yeah, the trust process or creating an estate plan is not as scary as you think it is. And it can be done in a fairly simple and comfortable way.
Thank you. That's a lot of great information. So how can people reach out to you if they want to start working on their estate planning?
So they can call our office, right? 650-503-3770. We are in San Mateo, so San Mateo County, but we serve all counties. And then our website, if you want to know more about me and my team, is yourlegacyprotectionfirm.com. And then we're also on social media as Legacy Protection Firm.
And again, author, coach, speaker. So if anyone needs,
so we have a book, and my book is actually the QBIC's Guide to Creating a Legacy, and it has some coaching exercises along with some information on estate planning. And so the idea is that we're creating this legacy, creating this wealth. Now let's make sure you protect it, and that book's on Amazon.
Wonderful. Thank you so much, Carmen.
Thank you.